Let's go to job contracting. This is a favorite topic in our examination, a hot issue, especially during the administration of President Duterte when he promised to end this contractualization, or the popularly known INDO. This is the legal basis. The question would be, is job contracting allowed under the labor code? Technically, yes. Article 106 of the labor code provides whenever an employer enters into a contract with another person for the performance of the former's work, the employees of the contractor and the latter subcontractor, if any, shall be paid in accordance with the provision of this code. So Article 106 gives us the legal basis for legitimate job contracting. And the law allows or provides for a safety measure that in the event the contractor or subcontractor fails to pay the wages of his employees in accordance with this code, the employer shall be jointly and severally liable with his contractor or subcontractor to such employees to the extent of the work performed under the contract, in the same manner and extent that he is liable to employees directly employed by him. When you say joint and severally liable, it means that you can sue either any of them because of this principle of liability. You can sue the contractor or you can sue the principal. The role of the Department of Labor is very important here when it comes to labor-only contracting. For that reason, our Secretary of Labor, Secretary Bello, issued Department Order number 174 just to address the problem of labor contracting. But the question is, unless you amend or modify or revise Article 106 of the Labor Code or improve, it's very hard for the Secretary of Labor to address this issue. Take note that there is that enforcement power of the Secretary of Labor. In fact, the Secretary of Labor can restrict or prohibit the contracting out of labor to protect the rights of workers under the Labor Code. So this is still found in Article 106. In so prohibiting, he may make appropriate distinctions between labor-only contracting and job contracting, as well as differentiation within these types of contracting, and determine who among the parties involved shall be considered the employer for purposes of this code to prevent violation or circumvention of any provision of this code. So, if you talk of legitimate job contracting, the Department of Labor also describes this as permissible job contracting. This is allowed under the following circumstances. We will discuss it one by one. What is prohibited by law is labor-only contracting. Or we will go to that later. So when DO 174 was enacted, Section 9 thereof provides, in the event of violation of the provision of the Labor Code, including failure to pay wages, there exists a solidary liability in the part of the principal and subcontractor for purposes of enforcing the provision of this code and other social legislation to the extent of the work performed under the employment contract. So the same ruling, we have to maintain that in case of failure to pay wages, even in legitimate job contracting, the liability is still solidary because the purpose of the law is to protect the workers. So there will be no pointing of fingers between the principal and the contractor. If you go for a labor complaint, you can sue any of them. So let's go first to legitimate job contracting before we go to labor-only contracting. So the Supreme Court has enriched us with jurisprudence regarding job contracting. Okay. When do we know, or when can we say that there is legitimate or permissible job contracting. Let's go to Section 8 of the Department Order number 174. According to this provision, the following circumstances must concur in order to conclude that there is legitimate job contracting. 1. The contractor or subcontractor is engaged in a distinct and independent business and undertaking to perform the job or work on its own responsibility. According to its own manner and method. Second, the contractor or subcontractor has substantial capital to carry out the job farmed out by the principal on his account, manner, and method. Investment in form of tools, equipments, machinery, and supervision. Third, in performing the work farmed out, the contractor or subcontractor is free from control and or direction of the principal in all matters connected with the performance of the work except as to result thereto. Service agreement. Lastly, the service agreement ensures compliance with all the rights and benefits for all employees of the contractor and subcontractor under the labor laws. So we have to start from here. If you will be given a scenario and will make you rule whether or not there is legitimate job contracting, check the following. So, just to summarize, the contractor must be engaged in a business independent of its own and is not subject to control by the principal. It has its own substantial capital, tools, and equipments, and the principal is only controlling the output. And more importantly, there must be in the service agreement between the principal and contractor an undertaking that all the rights and benefits of the employees under the agreement shall be provided and respected. When you talk of substantial capital, it refers to paid up capital stocks or shares of at least 5 million pesos in case of corporations, partnerships, and cooperatives. In case of single proprietorship, the net worth of at least 5 million pesos. Then, under DO 174, it requires the registration of all persons or entities acting as contractors. And failure to do so will give rise to the presumption that the contractor is labor-only contracting under Section 14. So, even if you have all the requirements at present, the requirements present, and if you don't register with the Department of Labor, you are presumed by law as a labor-only contractor. And your registration will only be valid for 2 years, and it can be cancelled based on the following grounds provided under Section 20 of DO 174. To name a few: misrepresentation of facts in application, submission of falsified or tampered application or supporting documents, non-submission of service agreement, which is very important because that's where you can find protection of the rights of workers, non-submission of semi-annual report as provided in Section 22, and final findings that the contractors engage labor-only contracting or other illicit forms of employment arrangement as provided in Section 6, non-compliance with labor standards and working conditions, finding of violations of Section 10, the rights of contractors, employees, and Section 11, the required contracts, non-compliance of SSS, collection of any fees not authorized by law, and violations of the provisions of the labor code. So any of those grounds, your registration will be cancelled. So in order for you to be registered with the Department of Labor, you need to submit the following contracts. There must be the employment contract between the contractor and his employees, and the service agreement between the principal and the contractor. These are very important documents because this service agreement will tell us whether or not there is undertaking of complying the minimum labor standard benefits. Okay, so we have cases even prior to DO 174 showing that there is no control by the principal, which means that the employees are independent contractors. You can visit the case of Jerome Escasinas and Ivan Rigor Cinco versus Shangri-La's Mactan Island Resort, and Dr. Jessica J.R. Pipito, March 4, 2009. Because the doctors here running the clinic of the hospital are considered independent contractors by the Supreme Court. So there is no employer-employee relationship. They do their own business, handling patients, the customer or customer patients of the resort. I also encountered this in Central Bank Circular number 1388, series of 1993, where bank services can be farmed out. The requirement is under the Central Bank Manual, Section 1177. A bank with expanded commercial banking activity, a banking authority, or a commercial bank may engage in bank service bureau or corporation to perform the following services. So this refers only to commercial bank, not other banks, like rural bank. That's not allowed. We're talking here of the following services that can be farmed out to a bureau or corporation. 1. Data processing, system development and maintenance, deposit and withdrawal recording, computation and recording of interest, service charges, penalties, and other fees. Check clearing processing, printing and delivery of bank statements, providing general support services, such as purchasing of bank forms, equipment, supplies, messengerial, janitorial, and services, necessary budget and expense accounting, and other similar services. So in this case, the bank may enter into a service agreement. Although this, if you try to analyze all of these services, they are necessary and desirable to a bank, the business of a bank. So we also have cases showing that in order for a corporation to become an independent contractor, it must be performed by an entity which acts independently. It means that the principal doesn't dictate on the manner on how the work is done. Otherwise, you'll be considered labor-only contractor. You have the case of Aliviado et al. Versus Procter & Gamble Incorporated and Prom Gym Incorporated, June 6, 2011. Regarding the requisites of the Department of Labor, the Supreme Court also mentioned in the case of Petron Corporation versus Arms Caberte et al., June 15, 2015, that in addition to the substantial capital, the employees recruited are performing activities that are directly related to the main business of the principal. It is labor-only contracting. So basic is the rule that these employees hired through agency must not be performing activities that are necessary or desirable in the usual trade or business of the principal. Otherwise, it will be considered labor-only contracting. The same ruling in the case of Aboitiz Howlers Incorporated versus Manauray, Dima Patoy et al., September 19, 2006. In the case of Iligan Cement Corporation versus Elias Corp, Employees and Workers Union, Southern Philippines Federation of Labor, and all its officers and members et al., April 24, 2009. The job of stockpilers, arrastri, and stevedores are related to the pursuit of cement business, so you cannot farm that out. Otherwise, it will be considered labor-only contracting. So many cases have reached the Supreme Court. So far, the ruling is consistent. As regards liability, the solidary liability, you have the case of Lapanday, Court of Appeals, January 31, 2000. There is several liability, several joint and several liability when it comes to non-payment of wages and other provisions of the labor code. What will happen? Let's now look at the nature of liability of legitimate job contracting. Because we don't have a problem with labor-only contracting because all liabilities come in. But if it is legitimate job contracting, then the solidary liability will come in only if there is non-payment of wages. If there is a wage increase, we have to remember that wage increases will immediately be effective, and the principal will be liable under the principle of amendment of contract. So if there is a wage order issued by the RTWPB, the service contract agreement between principal and the agency is deemed amended, and the agency will be liable to pay the wages subject to the wage differential, subject to reimbursement by the principal. So in case you want to distinguish now, it's very easy. If you don't qualify as a legitimate job contractor or impermissible job contracting, then you will be considered labor-only contracting. So the effect would be, one, the employees are considered employees of the principal, and the liability is encompassing because you are considered directly the employer of these employees hired through the subcontractor. So the difference would be is that when it comes to the joint and several liability, in case of permissible job contracting, the joint and several liability will only apply to wage increases and non-payment of wages. Other than that, there will be no liability on the part of the principal. We have to remember that in the service agreement between principal and the subcontractor, both will agree and undertake that there will be payment of other benefits provided for by law. So it is now the duty and responsibility of the subcontractor to pay all other wages or other monetary benefits other than wages, because by law the subcontractor is the employer of the employees hired through agency or under permissible job contracting. So if this contractor doesn't pay the wages as prescribed or the wage increase as prescribed in the wage order, then it will create a joint and several liability. The employer will be liable, the principal will be liable, at the same time the agency will be liable. So if you want to sue them, you can sue any of the two. That is the difference, because when we go to labor-only contracting, the liability is everything, because you are presumed an employee of the principal, because there is labor-only contracting. What about, I want to bring the attention of the case of Coca-Cola versus Alan Aguito et al., February 13, 2009. In this case, the agency is involved in is registered as a janitorial and allied agency. However, it delivered Coca-Cola product. So according to the Supreme Court, there is an ultra vires act performed by the agency. Instead of the workers performing janitorial work, they were made to deliver, distribute soft drinks, Coca-Cola products. So since this is outside the scope of the purpose of the business of the subcontractor, then according to the Supreme Court, the agency is engaged and Coca-Cola company is engaged in labor only contracting. Besides, the agency here, Interserve, did not have substantial capital investment. It's using the equipment of Coca-Cola, so it's really labor only contracting. There was also lack of control, no, between the agency and the employees. So the means and methods of how the products will be delivered, or the Coca-Cola products, were determined by the principal. So that is considered labor contracting. So even if you are registered with the DOLI as a legitimate job contracting, but you will do ultra vires acts and make the employees deliver or perform activities that are not included in the purpose of your registration, then you are considered labor only contractor or engaged in labor only contracting. So it's very easy to determine, because in labor only contracting is the principal exercising or directly controlling the conduct of the work. In connection with labor only contracting, Department Order Number 18, Series of 2002, declared prohibited is what we call in-house agency. In this case, this in-house agency refers to the employer creating its own agency and provides workers a blatant circumvention of employee security of tenure. So in-house agency is prohibited because it is a form of labor only contracting. So regarding the contract, the service agreement, as I mentioned earlier, there is that case of Security and Credit Investigation et al. Versus NRC, July 26, 2001. In case of the service agreement or service agreement providing security guards, if there is a wage increase, according to Supreme Court, there is automatic amendment of contract by operation of law. Therefore, the principal is liable to pay the wage increase differential. Regarding cooperatives, they can do the act or perform the services of a legitimate job contracting or job contractor. Under Section 3 of Department Circular Number 1, Series of 2007, it provides that cooperatives engaged in contracting and subcontracting must fully comply with the requirements and provided for by DOLI and under 106 to 109 of the Labor Code, and registered the same with the Department of Labor. Regarding evidence, the case of Petron Corporation vs. Cabertit tell us, by the way, it's June 15, 2015. According to Supreme Court, the law presumes a contractor to be labor only contractor. labor-only contractor, and the employees are not expected to prove the negative fact that the contractor is labor-only contractor. Where the principal is the one claiming that the contractor is legitimate, with the contractor burden of proving. When the principal is one claiming that contractor is a legitimate contractor, the burden of proving the supposed status of the contractor rests on the principal. So this is a matter of evidence, especially if the principal will allege that the contractor is legitimate. So the normal questions asked here is labor-only contracting. So when is there labor-only contracting? So remember the requirements laid down by the Department Order 174. In the absence of any of those, they are considered labor-only contracting. Another, from the jurisprudence, you have to determine also, even if you are a legitimate job contractor but you perform ultra various acts and your employees are performing jobs, in the case of Coca-Cola, delivering Coca-Cola product, when you are a janitorial company, then you can be considered labor-only contractor. And even if you are a legitimate job contractor but you provide employees to the principal, and it is the principal who has control or exercise control over the manner and the methods and how the end will be achieved, then it will also give rise to the presumption of labor-only contracting, even if you are a registered legitimate job contractor. So the criterion, therefore, very important criterion when it comes to declaration of labor-only contracting is the question of who exercises control over the conduct or the manner of the work and how it is performed. I think that would be all for legitimate job contracting. So we started with the definition of legitimate job contracting, then we went to labor-only contracting. So it will now be easier for you to understand. It's a very popular question in bar examination. There will always be labor-only contracting question that will lead to termination of employment, and the consequences of illegal dismissal will also be applicable, like back wages, separation pay, etc. That will also this clip. We will continue the next topic in the next clip.